Day 20 of talking about estate planning and domestic violence. And I'm going to tell you, today's topic makes me feel a little gross, okay? We're going to talk about limiting powers of attorney if you give that power to an abuser so that they can not completely abuse the power. See how that sounds just yucky? It's not something I advise, but it is the reality for some people. The reality is some people are going to choose to stay with abusers in certain scenarios, and we have to trust that victims know their situation better than anyone on the outside could know their situation. And sometimes the safest thing to do is to stay with an abuser. And in those scenarios, it may be the most practical for that person to also be the person who has, for example, statutory power of attorney, if not medical power of attorney, because you may have combined finances, and it may make sense for them to be the person making some financial decisions for you. On the other hand, we've already talked about financial abuse. We've already talked about power and control and how controlling the money can give an abuser an additional means of abuse. We don't want to do that. So what can we do? An attorney can draft a durable power of attorney and even a medical power of attorney with specific limitations that can balance their authority and decision-making abilities with some controls that you put into it. We can carefully craft these documents to have them reflect whatever it is you want. Now, you saw my face when I started this conversation. Most attorneys can be a little uncomfortable with that. And you might need to talk to them and really describe the situation and stuff so they understand what it is you want so that they can make sure that your wishes are observed and they can work with you to create the estate plan that you desire.